Hello everyone. In this video, we'll be trying to find a nexus between trademark and domain name per se. As you know, domain names are basically internet addresses. They facilitate international commerce and global exchange of knowledge. Let's understand what are domain names, what are the different kind of domain name disputes, and what is the relationship that we are going to establish with trademarks per se. Okay, as you can see that over here we have been trying to understand what domain name is. So a domain name is basically a internet address, right? Domain names are internet addresses that help users to locate the websites. Domain names have with time assumed key role in e-commerce. It facilitates the ability of consumers to navigate the internet, to find the websites, and also facilitates business by serving to identify and distinguish the businesses itself or the goods and services, and to specify the internet location. So now as you can see that over here I have mentioned about www.tata.com. So the reason why I have mentioned a particular domain name is that first of all we are going to understand how do we build a relationship between a domain name and a trademark per se. So as you can see here we have Tata, right? We have Tata written over here. So Tata is basically a trademark, right? So now because Tata is a trademark, that is a kind of business identifier, it is somewhere a particular web portal which is trying to establish a nexus between the trademark that is there in the real world as well. So we can say that domain names are basically the intangible manifestation. It is the cyberspace, it is the cyber domain in which Tata has established itself, right? So with www.tata.com, the Tata group is trying to make people know of the different kinds of goods and services that they are actually selling in the market. So this becomes their internet address, right? This becomes their internet source of making people know about them, right? When we try to talk about the relationship between domain names and trademarks, we first of all have to understand the relevance of cyberspace with regard to trademarks, right? So if you look into cyberspace as a particular digital world or a virtual world, you can see that this digital world is nothing but a real manifestation. It is a kind of extension, right? It is a kind of extension or manifestation of the things that happen in the real world, right? It is an intangible aspect of the tangible things that happen in the real world, right? It is that part of the space. Cyberspace is that part or that kind of space which connects you to the group, Tata group per se. Like through internet you are connected to the Tata group per se. So here this particular web address www.tata.com acts as a internet source, acts as a internet identifier for the Tata group. So here you can establish a relationship between www.tata.com, which is acting as a particular website by virtue of which you can identify the goods and services that Tata Group provide in the tangible world per se, right? So the effects are same and the same parties are involved, right? Whoever is involved in the Tata Group in the real world is similarly involved in the virtual world as well. So the effects are same and the same parties are also involved in this, right? So now as you can see, www.tata.com, we can see that it is basically this tata.com. .com is this portion. .com is basically the top level domain, right? It is also called the TLD, top level domain. Top level domain is divided into, subclassified into two types: generic top level domain and country code top level domain. So this is not the part where we identify our trademark. Our trademark is basically this second level domain, right? So this Tata is basically becoming the domain name, the address, which helps us identify a particular trademark, right? It identifies a source in the real world per se, right? So it is a kind of trademark that is prevalent in the cyberspace. It acts with regard to identification. It is serving the purpose of identification in the virtual world, right? So that is how you relate a domain name to a trademark per se. So as I said that, domain names, with the advent of internet, it is almost a necessity for businesses to exist in the world wide web, uh, regardless of whether they conduct business transactions through this virtual medium or not. So by means of saying this, there are also very information based websites which only provide information, but you cannot transact through that particular web portal, but they provide you information with regard to the goods and services that provide. So that is why they are established on the internet, but they're not carrying out active businesses through internet, but they have an internet presence, right? So it is almost a necessity to have an internet presence in today's world, and somehow domain names serve that purpose. They establish their internet presence through this, right? In order to exist in the virtual world, all businesses will have to register a domain name which acts as an online address through which they can connect and communicate with their customers. Thus, a domain name is nothing but an address through which a person or an entity can communicate with the public. So you can understand how domain names are actually related to trademarks per se, how they serve the same purpose of identification and communication with the consumers per se. The internet protocol system, the IP addresses that were there before, right? So those IP addresses were composed of mere numbers, right? So these mere numbers could not really readily connect with the consumers, but when domain names were there, domain names actually facilitated that purpose, like that of www.apple.com or samsung.com, and for example tata.com as well. So they convey to the customer that internet addresses may be directly related to the goods that are supplied by the particular entity, right? For example, electronic goods that are supplied by manufacturers Apple Incorporation and Samsung, right? So domain names related to the consumers, whereas in this scenario, internet protocol systems, the IP addresses that were there, they did not establish a relationship. So IP addresses could not be related to trademarks per se, but when we talk about domain names, because they established a connection between the consumers and the particular business entity, for example the Apple Incorporation and the consumers of Apple Incorporation, they established a communication between them, like www.apple.com would act as a source through which they would relate to the services that apple.com is going to provide, to the goods that apple.com is going to provide. So that is why it establishes a connection, right? The domain names establish a connection. The domain name is a simpler way of connecting with the public, and it functions just like a trademark. The domain name acts as a source identifier, wherein the consumer browsing the particular address is likely to think that the website is related to a particular business or trader. For instance, a person browsing through www.apple.com is likely to associate the domain name with the well-known electronic goods company Apple. Such an association means that domain names function just like trademarks. So when we talk about domain names per se, WIPO, World Intellectual Property Organization, in June 1998 accepted a United States proposal for a consistent international approach, right? And through this only ICANN was formed, Internet Corporation for Assigned Names and Numbers. So this ICANN was a particular internet technical coordination body which was assigned a task of creating a uniform administrative procedure for the resolution of disputes concerning generic top level domain registrations. ICANN was thus responsible for the management of the internet domain name systems and the stable operation of the internet root server system. So uh, the accredited registrars of ICANN have the responsibility of assigning domain names. However, the basis for granting domain name is not based on the requirements stated in the trademark legislations. Instead, registration is based on first to apply basis. So this particular aspect of registration given on first come first serve basis, this has given rise to multiple issues like that of cyber squatting and frivolous disputes. So let's understand this particularly. When we talk about domain names are given on a first come first serve basis. So there is no substantial examination of whether a particular person, whether a particular entity should be given a trademark or not. We know that in case of normal trademarks, in case of trademarks per se, there is a registering body and the registering body has done substantial examination of distinctiveness of graphical representation, whether there is a particular locus standi of the person wanting to have a registration. It also determines whether there is a good faith registration or not, right? So there are various things which get examined when you want to register a trademark per se. That does not exist in case of domain names. That kind of substantive examination does not happen in case of domain names. Domain name registrations do not require the trader or the business to establish distinctiveness. As a result of this, a person or company totally unconnected with the business can seek registration of domain names. For instance, Apple, being a well-known company for electronic goods like computers, laptops, mobile phones or tablets, right? It is a well-known company. But if a person or an entity totally unconnected with that of the Apple company, right? Like if there is a particular entity which does not really know Apple per se, right? But this particular entity which is totally unconnected with the well-known company, if that person or entity is the first to apply for a domain name, that is www.apple.com, then it may be granted a domain name, right? So here in this scenario, the internet users browsing the website might come under the wrong impression that the above domain name is related to Apple per se. So here it would confuse the consumers and may also prove to be an expensive proposition to a company if it is not the first to register. So you can see that the disputes that would arise, these disputes arise only because there is no substantive examination with regard to domain names, right? So here there are various kinds of disputes that arise. For the first dispute that we are going to be discussing here is cyber squatting. So what is cyber squatting? Cyber squatting is basically registering, selling or using a domain name reflecting the trademark or brand name of another existing company for the purpose of making profit. So what cyber squatting or cyber squatters do is they occupy, right? They occupy or buy a domain name that contain another person's trademark or brand name, right? So here the cyber squatter buys the domain name having the names of existing brands and then sells them back to the lawful owners at a premium, thus making huge money out of such transaction. A person who has nothing to do with the domain name thus pirates it to earn profit. For example, if yahoo.com is registered as yahoo.org with a top level domain, or www.yahoo.com is omitted, or for example Yahoo is registered as yahoo.com, then there is a deliberate misspelling, and by virtue of which cyber squatting can be done, right? So that is how a person or an entity is having a bad faith, right? He's doing a bad faith registration. He's registering and trying to sell back that domain name to the original user, right? He's registering a domain name which is not of his, right? So he's registering a domain name in a bad faith, right? So this cyber squatters then demand a huge sum of money from the original owners, right, in order to give up that domain name. So this gives rise to a lot of disputes. So this is not the only kind of dispute. There are also other instances. For example, these are good faith registrations actually. For example, if there are two companies in trademarks, as we know that there is a honest concurrent user registration. For example, if two people have a particular good faith registration because both of them are entities who have a right towards a same trademark, both of them have a right towards it. So in this case, in trademark law, both of them can actually be present in the market with their own trademarks because both of them are good faith people, like both of them have good faith registrations, both of them are honest concurrent users. But that does not exist in case of domain names. Only one person can get that domain name. So here this also creates issues, right? For example, concurrent claims, when both of them have both of them are people who are legitimate parties, right? Two legitimate parties who are involved in a dispute, right? These are two legitimate parties who have a good claim over a domain name. So they get involved in a dispute because both of them have a good claim over a particular domain name, but on account of having similar marks. In trademark law, they can exist, but in case of domain names, they can't. So that is why this creates genuine disputes, and this also gives rise to bad faith disputes as in case of cyber squatting, right? So domain name registration also, as you can see, I have put it here that domain name registrations do not resolve the problem related to companies that may have same or similar names but are trading in different class of goods and services, right? We know that in case of regular trademarks, if you have non-competing goods, then in that case you can still serve in the market, right? If you're not a well-known trademark, then in that scenario, if you are dealing with different class of goods and services, you can serve in the market, right? So domain name registrations do not really solve that purpose as well. uh, Trademark legislations accommodate similar marks if they are used to indicate goods and services of different class. However, domain names cannot accommodate similar or same name even if the companies are trading in different classes of goods or services. So these kind of disputes keep arising. For example, if you remember, we had studied about Goenka, the Goenka school, the Goenka University case. So that was a particular case with regard to surname. So you saw how the court had allowed both the parties to be using the Goenka surname for their schools, but that was with regard to different entities, right? They had classified it according to different classes, right? In like for the same class they could not use, but for different classes they could use the same trademark, right? So in that scenario, there a particular leeway was provided for both the entities to co-survive, but this was not a possibility with regard to domain names. So this was another type of issue that was arising. Okay, so till now we have understood about ICANN and the different kind of domain name disputes that are there. Now we are going to be discussing about resolving domain name disputes. So when domain name disputes arise, it can either be resolved through a system called the Uniform Dispute Resolution Policy, that is UDRP, that is set up by ICANN, or it can be resolved through the traditional trademark law. As per Rule 4 of UDRP, if a third party alleges that the registered domain name is similar or identical to a trademark, or that it has been registered in the absence of good faith, or that there is no legitimate interest, then the owner of the domain name will have to submit to the Uniform Dispute Resolution Policy to resolve the dispute. Right? So these are the grounds under which a particular party can allege that a domain name is somewhat, it should not be registered in that particular scenario, or the registration should be cancelled per se. These are the grounds, right? uh, if a trademark owner manages to prove all the three allegations, the domain name then may be transferred to the genuine owner of the trademark, right? Or it may be cancelled per se. Traditional passing of suit may also be used to resolve domain name disputes. In a traditional passing of action, the plaintiff will have to prove that there is goodwill and reputation attached to his goods, and that the defendant has misrepresented to the public that its goods are the goods of the plaintiff per se, and as a result of this misrepresentation he has suffered damages, right? So here, this, if in case you're not trying for the arbitration remedy under Uniform Dispute Resolution Policy, then in that scenario you have a remedy, you have a judicial remedy uh, of filing a suit for common law passing off. You have a remedy, you have a traditional remedy of passing off available to you. And if you file for the traditional remedy of passing off, you need to uh, prove that that there was certain amount of goodwill and reputation that was attached to the goods of the plaintiff, and the defendant, that is a person who has registered the domain name, has misrepresented to the public that the goods, that his goods are the goods of the plaintiff, and as a result of this misrepresentation the plaintiff has suffered damages. So these three are the grounds of passing off that a particular plaintiff has to prove in order to get a particular domain name registration cancelled, right? Similarly, in case of domain name disputes, a passing of action can be brought in the Indian courts if the domain name is registered to mislead consumers to believe that it is related to a reputed mark. Then it is easy to prove misrepresentation. Similarly, domain name can mislead the consumers if it is identical or similar to that of a known trademark. So you can see that there are basically two kinds of remedies that are available. One is a arbitration remedy that is available under UDRP, and another is a remedy that is available under the traditional passing off, right? So there is a traditional passing off remedy that you can get while filing a particular suit in Indian courts, right, or in the courts per se, or there is a arbitration remedy that is available to you where you file it to the, when you go to the UDRP, where you follow the procedures of UDRP under ICANN, right? If a domain name is registered with the intention of causing confusion to the consumers, then the owner of trademark can always say that it leads to diversion of users. The Supreme Court of India has affirmed that domain name has all traits of trademark, and as such, a passing of action can be brought to resolve a domain name dispute. In the case of Yahoo Incorporation versus Akash Arora, for the first time, the Indian court had particularly said that a particular domain name is equivalent to a trademark, and there they will be treated in a way equivalent to a trademark, right? Uh, Here But here we'll be discussing Satyam Infoway versus Sifinet Solutions. So in this case, it was held that a prior user can prevent the subsequent user from using a similarly sounding domain name, as it results in damaging the goodwill of a prior user. So Satyam Infoway had registered domain names sifinet.com, sifimall.com, sifirealestate.com, right? So here they were using SIFY, whereas Sifinet Solutions, who was the subsequent user, was an internet marketing company who was using the domain name Sifinet, double F, right? So here you can see there is a particular typo squatting. One is using one F, another is using double F, right? So Sifinet Solutions started using SIFFY. So Satyam Infoway claimed that it would lead to confusion, as consumers would think that Sifinet, as in Sifinet Solutions, is linked or associated to the prior user's domain name, that is Sifinet, as in Sifinet Solutions are related to Satyam Infoway. In this case, the Supreme Court ruled that this did result in passing off, and they they cancelled the registration of Sifinet Solutions. So you can see that there have been accounts in which the Supreme Court of India, or there are in different cases, the particular courts in India have treated domain names as trademarks and have allowed passing of actions, right? So Yahoo Incorporation versus Akash Arora and Satyam Infoway versus Sifinet Solutions, these are certain landmark cases with regard to the Indian courts who have decided with regard to the difference, the similarity that exists in between domain names and trademarks, right? They have decided in favor of that the domain names should be treated in trademarks, and passing of remedy has been given by the courts, right? So you can see that all in all, there are two kinds of remedies that are available. One is a arbitration remedy, and another is a passing off remedy that is available. So there are different cases that are there. Um, if we get chance, we might discuss Morgan Stanley versus Bharat Jen, or I'll send you a document in which you can read it. There are different cases that are there, uh, that you can find in the document per se. Also, as you can see, in India per se, right here, what I discussed, ICANN was a particular is a particular body by WIPO. In India, there is a .in registry which registered the domain names, and for resolving disputes pertaining to the .in domains, NIXI, that is National Internet Exchange of India, has evolved a dispute resolution mechanism, uh, namely .indrp, that is .in domain name dispute resolution policy, that is formulated in lines with the UDRP, right? It is in line with the policies and the formulations that have been accepted by Uniform Dispute Resolution Policy by WIPO. So you can see in India, NIXI, that is National Internet Exchange India, in contact with the Ministry of Communications and Information Technology and the Department of Electronics and Information Technology, that is DATI, right? So all of these bodies have tried formulating a dispute resolution policy, which is called the INDRP. That is the kind of arbitration process that is there in India, and also there is the common law of passing. That is, there is a common law remedy of passing off that is available. And when we talk about WIPO, there is UDRP, there is ICANN, who are trying to resolve domain name disputes through that process. Okay, thank you so much. This was all with regard to domain names, domain name disputes that arise, and the resolution of those disputes. Thank you so much.